legal advisor. Let me introduce that we are joined also by the executive secretary by the name of Tswaki Mapili. She has just started whilst we were busy on the oversight. Now she is with us and I wanted to introduce her, but without wasting our time for the legal advisor. Let's allow the legal advisor to get into the job. Let's first request the agenda to be flagged and be adopted, etc., etc.
Morning, members. Morning, everybody. This is the
Morning.
agenda for the day, Chair.
It's so small, I can't even see it. Okay,
Make
it's
it bigger.
better now. Yes, it is better. Yes, adoption needs to be done, and also any apologies that you have, except the one of Ariko. Let me inform the committee members that Ariko's leave has been extended by the doctor, the sick leave, so by a week. So we won't have Ariko with us for the week, and then we hope and wish him speedy recovery, and then we'll proceed. Any honorable member to adopt the agenda?
Myself, Chair, Honorable Hassan.
Honorable Hassan.
Thank you, Chair. I'm happy to move for the adoption of the agenda as has been presented. Thank you.
Thank you very much, Honorable Hassan. Any seconder?
Chair, I will second.
Thank you very much, Honorable Bapti. The agenda has been duly adopted and seconded. Then, if it is the case, we will go to the briefing by the Parliamentary Legal Service on its legal action as it has been approved. Over to you, legal advisor.
Thank you, Chairperson, and good morning to you, Chairperson, and good morning to all members on the platform and to everybody else on the platform. Chairperson, let me first just thank you and the committee for the indulgence regarding my availability. It is appreciated and I am indebted. Chairperson, may I ask, now that I have shown the committee who I am, my surname is Gangan, my name is Tiloshni. I'm one of the legal advisors at the Parliamentary Legal Services. May I ask for permission to switch off my camera so that the papers do not fly all over?
Okay, you are allowed. I will also switch mine. I will switch off mine. Thank you.
Thank you. I'm indebted. Thank you, Chairperson.
Thank you.
Chairperson, let me start by just giving the quick background. The committee has requested a legal opinion on whether the Act requires Parliament to shortlist, interview, and to make recommendations for the Minister's consideration. And if answered in the affirmative, the committee requested guidance on the process of shortlisting. I had prepared a legal opinion, which I understand has been shared with all the members. So I'm just going to run through the opinion, and I'm not going to read verbatim. So I started with the legal framework, Chairperson, and our starting point should always be the Constitution. And I say to the committee that Section 42(3) of the Constitution deals with the provision of a national forum for public consideration of issues. Section 59(1)(a) deals with the responsibility of the National Assembly to involve the public in its processes and of its committees. It says 59.1, the National Assembly must facilitate public involvement in the legislative and other processes of the Assembly and its committees, and that we need to conduct its business in an open manner, hold its sittings and those of its committees in public, and reasonable measures may be taken to regulate public access, including access of the media to the Assembly and to its committees. The next port of call place to look is the rules of the National Assembly. So section 167 of the National Assembly rules deals with the general powers of committees, and paragraph F says the general powers of the committees. It empowers committees to determine its own working arrangements. Rule 227 deals with the functions of committees, and it says that portfolio committee must deal with bills and other matters falling within its portfolio, as referred to in terms of the Constitution, legislation, the rules and the joint rules, or by resolution of the Assembly. It further states that committees must maintain oversight of the exercise of national executive authority and any organ of state within its portfolio. And in doing so, portfolio committees may monitor, investigate, inquire into, and make recommendations concerning any such executive organ of state, constitutional institution, or body or institution. Section 3, the next thing we'd like to look at is the National Nuclear Regulator Act. Section 3 of the Act establishes the new National Nuclear Regulator as a juristic person comprising of a board. Section 3.2 states that the regulator is a Schedule 3A public entity in terms of the PFMA, the Public Finance Management Act. Section 8.4a deals with the composition of the board. It says the board comprises of directors, and it gives a host of candidates. So one representative of organized labor, one representative of organized business, one person representing communities which may be affected by nuclear activities, an official from the department responsible for mineral resource and energy, an official from the department responsible for the environment, and not more than 7 other directors. Section 8.6 of the Act stipulates that a person may only be appointed as a director if he or she is suitably qualified. Section 8.7 of the Act states that for purposes of appointing directors of the board, the minister must, through the media and by notice in the Gazette, invite nominations of persons of candidates for relevant positions of the board. Section 8.7b of the Act states that the relevant portfolio committee of the National Assembly must compile a shortlist of not more than 20 candidates from persons so nominated. Section 8.7c of the Act provides that in addition to persons contemplated in subsections 4A, 4, and subsection 5, the minister must, from the shortlist so compiled, appoint persons to the relevant positions on the board. Section 8.7d of the Act says that the minister must, for a director appointed in terms of the above section that I've just quoted of the Act, appoint a suitably qualified alternate director to act in the place of that director during his or her absence. And Section 8 of the Act provides for disqualification criteria, and it says that the section provides that a person may not be appointed as or remain a director if he or she is not a South African citizen, is declared insolvent, is convicted of an offence and sentenced to imprisonment without the option of a fine, becomes a member of Parliament, a provincial legislature, a municipal council, the cabinet, or the executive council of a province. E is an authorization holder or employee of such holder. Section 8.16 provides that the members of the board must, when viewed collectively, be persons who are suited to serve in the board by virtue of their qualifications, expertise, and experience in the fields of nuclear science, technology, and engineering, finance, risk, corporate governance, law, and strategic leadership. Must be persons who are committed to fairness and accountability on the part of those holding public office, and must be persons committed to the objects and the principles enunciated in the Charter and the Code of Conduct of the Regulator. In terms of Section 87B, 87B of the Act is preemptory. Hence, the Portfolio Committee must compile the shortlist of not more than 20 candidates from persons so nominated. The legislative framework is found in sections 3, 8.4, 8.6, 8.7, 8.8, 8.15, and 8.16 of the Act. And essentially, the shortlisting must put the minister in a position to make the necessary appointments in accordance with the Act. The committee must take into account, with regards to shortlisting, the nominations received from the minister and compiling the shortlist itself. The persons shortlisted must be eligible and must not be subject to the disqualification criteria as explained earlier, must be able to represent various stakeholders, and must be qualified in terms of Section 8.6 and Sections 8.6 and 8.16, and must be able to fulfill the role as the accounting authority in Sections 3 and 8.15. The shortlist, essentially, the shortlist must comply with Sections 8.7b by not having more than 20 names, and must contain the requisite diversity to put the minister in a position to appoint alternate directors as envisaged in Section 8.7d. The process of shortlisting is subject to the constitutional requirements of procedural rationality, specifically this facilitation of public involvement. A failure to comply with these requirements will render the appointment process constitutionally invalid. I then go on to quote the Corruption Watch case, where the Constitutional Court had set aside the appointment of members to the Commission for Gender Equality after finding that the relevant portfolio committee failed to facilitate reasonable and public involvement in the nomination and shortlisting process. So, informed by what we've mentioned above, the committee must be guided by the Act when shortlisting nominations, and the process to facilitate public involvement would involve publication of a notice to invite comments from the public on candidates. Information about the candidates must be published. For example, the CVs of candidates, and such publication will not fall foul of POPI, Protection of Personal Information Act. And following the process, candidates who qualify in terms of the provisions of the Act must be considered. The committee may consider interviewing nominees who could potentially be on the shortlist, and that the final selection of not more than 20 candidates from the nominees must be submitted to the minister in a transparent way. Chairperson, that in essence is the nub of the legal opinion that I had furnished the committee with. Thank you, Chairperson.
Okay, thank you very much, Advisor. Then let's request the honorable members to interact with this presentation so that by the time you are recused, you at least manage to answer some questions and some clarifications. Let me check the hands. I can see that Honorable Njabeleng's hand is up, followed by Honorable Maileman Bapti for now. Over to you, Honorable Njabele.
Good morning, and thank you so much, Chair. I actually raised my hand for earlier with regards
Earlier,
to seeing, because I wanted to, we didn't see the presentation. I don't know if it was my device or what on the presentation. So I just wanted to inquire about the presentation because I could hear the voice, but there was no presentation.
Okay. Can we then request Lee to share the presentation to the members through emails right now?
Hi, Chair. There's no presentation, it's just the legal opinion that was sent.
That's what we are talking about,
Must
the
I
legal
resend it?
opinion.
Okay, I'll
Yes,
resend it.
thank you very much. Honorable Kevin Malila?
Thank you, Chairperson. Chair, I'm just curious as to why we felt that there was a need for a legal opinion. The legislation is very clear that we do have an obligation to shortlist. I have no recollection of this committee requesting a legal opinion on this matter. So can I get some clarity as to that, please?
Okay. Maybe let me also assist and answer that without referring it to anyone. It's the committee members that requested that we have to have a briefing. Even this briefing was gonna be physical, but it's just that, as I have said already, that the advisor will have to be recused. Yes, it is clear, you might be familiar with it, Wenane, as Honorable Maile, but not every member and all the members that are familiar with, like myself, which I also needed not to break some laws and acts and etc. But nevertheless, it's not gonna be a train smash. She is here today, it's clear. Then as we request that Uli must share that information with other members, those that are in need of it. The second hand is from Honorable Bapti.
Good morning, Chair, and thank you. Chair, my question has to do with the public participation. From the Regulator Act and from the case law, the public participation has to take place. My question is there a recommended time frame for that participation to take place?
Thank you, Honorable Bapti. Legal advisor?
Thank you, Chairperson. There is no recommended time frame in terms of the Act. What will guide us, though, would always just be, it needs to be reasonable, and the process needs to be fair. So it cannot be rushed. So the corruption watch case is the guiding case law on this at the moment. As you will know, the judgment was handed down fairly recently, 1st of August 2025. And what had happened in this particular case is that the candidates were only allowed 14 days to provide their written submissions, and then the court held that was far too short. And over and above that, in terms of actually applying online, where you put in your submissions, there was a limit of a 2,000 character limit on the submission, and people felt that the public felt that was far too restrictive in terms of the applicants. So I think if we were to have regard to the corruption watch case, 14 days was deemed to be too short, and it needs to just be reasonable and fair and open and transparent. So we need to be guided by the constitutional principles as well as the case law that aimed to guide us in the corruption watch case. Thank you, Chairperson.
Thank you, Lika. There is I don't understand what is this name. There is a name that I can't read. The hand is up.
Is it not
Morgan.
myself, Chair, Honourable Thring?
It's Mr.
No,
It's
it's
Mr.
not
Paulson.
you.
Honorable
It's Mr.
Paulson.
Paulson, Chair.
It's Paulson. Okay. Honorable Paulson, followed by Honorable Singh.
Good morning, Chairperson. Good morning, colleagues, and thank you very much, Chairperson. I don't want to sound too patriarchal, but you do look very beautiful today. Chairperson, thank you very much for the legal opinion. I just have one issue here is that telling us that sufficient time, it's too open. We need a timeline as to how this process will unfold, when we will start receiving the CVs of the applicants. I think it's very clear what the legislation is around this. Section 87B of the Act. We must compile a shortlist of no more than 20 candidates from the nominations received, and that the minister must appoint from this list that we will compile. And also that the National Nuclear Regulatory Board is more about it's not to promote nuclear energy, but to ensure nuclear safety. So that requires that we must have the expertise within that particular board. So I think it's very important that we allow this, that we need a sort of timeline as to how this whole process of appointing the board will unfold. And we don't have to put in dates, but just as to an idea as to when we will publish or invite nominations, and when we will receive them, and when we will do the shortlisting. I think that would give us a fair idea, and then we can just put that process into the parliamentary program, and that would be a good starting point for now. Thank you very much, Chairperson.
Okay. Thank you. I will come after after Honorable Tring and Honorable Ngos.
Can I proceed, Chair?
Yes.
Thank you. Chair, firstly, my apologies for logging a bit late. I'm having issues with parking around the parliamentary area, but apologies for that. But Chair, I think in the meeting where the appointment of the candidates for the committee have been raised, I did indicate that from previous experience in the last administration, we had former Minister of DTIC, Minister Patel, who had gone ahead and appointed board members, and it had come I think it was the Lottery Commission. It came to the attention of the committee, and Minister Patel had to withdraw because legal opinion, then when we sought legal opinion actually said it is the committee that has to nominate a shortlist members, and then the minister appoints from that shortlist. So I did raise this in the previous committee, and I think that what we now need to do is follow the legal advice that we have been given, which ties in with my previous experience, and then allow for the committee to tie up all of the secretariat rather, to tie up together with legal, to tie up all of the loose ends in terms of ensuring that the CVs there's sufficient time that has been given, the CVs are all collected and presented to the committee for the committee then to apply its mind in the shortlisting process. So I think that's the way forward, Chair, and we need to accept the legal advice that has been given. it is how things are done within Parliament and with the appointment of the board members. Thank you, Chair.
Thank you, Honorable Zeng. Honorable Vose.
Thank you very much, Honorable Chair. And thank you very much, Chair, for organizing the legal team to advise the committee. And we welcome the legal advice. Honorable Chair, the Act doesn't really strictly mandate the interviews, but the legal advice suggests that the committee may consider them. I just wanted to check this, Chair, that does the committee have the timeline and the budget to interview a subset of 120 applicants before finalizing the 20-person shortlist? Chair, and who is responsible for the initial reduction of the received CVs and nominations? And is this function performed by the department officials, an independent panel, or is it an external service provider? I just wanted to check that first, Chair.
Thank you, Honorable Vose. I think the last hand is Honorable Fasia.
Okay, all right, Chair. Chair, I had another question actually. I wanted maybe to, I thought maybe it is a question and answer. Can I give the second question, then we can proceed?
Yes, give the second question. The reason for that is that I told you and inform you that the legal advisor requested to be recused by 10.
Okay, no, thanks, Chair. The secondly, Chair, with respect to the NNR appointment processes, will interviews be conducted as part of the selection procedure? If so, and Chair, I wanted to check in what format will those interviews take place? That is the second question. Thank you,
Okay.
Chair.
Okay.
Last hand from Honorable Fasia.
Thanks very much, Chairperson. I think it's also been clarified that members wanted that legal opinion, and it is helpful given that it's the first time we're doing it for this particular administration. So I think there is benefit in hearing. I want to follow on some of the questions that have been put forward. So according to the Corruption Watch versus the Speaker case, they spoke about the fact that CVs must be published publicly, and that it would be in line with each CV, removing contact numbers, addresses. There's a number of things you have to take out for it to be POPI compliant, but also to protect those people, because if I'm right, like 120, it's 120 applications or basically the ones that have come to us. So I want to know who's going to do that, because in terms of budget and capacity, we are already strained as a portfolio committee, and I don't know if it's the department, but of course, the Act says we must do the shortlisting, in that then submit to the minister. Minister will appoint. So I think that's clear. We are not appointing. We are just submitting a short list of 20. We can submit 17, but we can't submit 21. So I think it just must be a 20 amount. So that's the first point. The second is, and I think someone did ask this, we heard from yourself, ma'am, that the 14 days was considered insufficient, but is it then 30 days? Is it that the 14 days was fine, but it was the 2,000 character issue? So we just want to understand what is the exact requirement for us, so that when we come up with the timeline, it's A, achievable, but B, it's also going to fit within the portfolio committee timetable, which is another challenge because of how tight things are. And then, Chair, I just want to understand, in terms of the 20 that we're going to recommend, I just need to understand, because I don't know, are we just going to recommend the 20 and then from there the minister will appoint, or is there another particular process? Because I understand that we need to send through the 20 names, but of course, let me understand this, it is at the minister's then discretion to appoint whoever is fit and proper, because we will have decided that these 20 people of the 120 are the ones you could appoint, and then is it at his discretion thereafter? Thank you.
Okay, I can see the hand of follow-up from Honorable Mylem, and then the last one is Honorable Njabuleng.
Thank you, Chair. Just a very quick one. And I'm not sure how we deal with this, so maybe this is a good opportunity to ask the legal advisors. We received a list of nominees, but there were a number of nominees that I was aware of that were sent through to the director, the acting DG, in August last year. In fact, I can give you the exact date. Well, I don't actually have it, sorry, but it was in August last year, that are not on the list of nominees. And those were particularly for the vacancies of the community representative. Now, can I ask, what is the situation with dealing with those nominations that were sent through that have not been included? Do we include them or not? Or how do we deal with this matter? Thank you, Chair.
Thank you, Honorable Ntshavheni, so that we can also respond in some of others, though I'm not a legal advisor, but I can have some answers that are not technical.
Good morning, Chair, and the members, as well as the guests. Thank you so much for the legal opinion from the legal services, and we welcome it. The key thing is, one, I would have loved to see the presentation. I didn't get the chance to really get to see it properly, but yes, as stated that we have an obligation. In the presentation, I think I would have appreciated to see the processes to which element, because really our concern is ourselves as the committee, what we need to do in respect to expediting the process of one, selecting, as well as shortlisting. And before actually the selecting, we have to do what needs to be done. You cannot shortlist unless you have gone through the process of checking validity of every requirement with regards to the application on the CVs. Then the secondary part of it is the selection of those that are actually credible applications that goes through the system. Then the shortlisting of the 20 names, that's going to be a critical process, because when we come to the shortlisting, what criteria are we going to use? So I think I wanted to understand clearly from legal, is there a particular criteria that we need to apply, apart from the requirement of saying there must be a union, there must be a public representative, there must be a member from the department, etc. Is there a particular requirement at a skill, technical, etc. level that is specified? That's question number one. Then moving on to the next element of it is, I mean, do we have to, before we select, subject, for instance, the 120 people through a screening interview? Because at times I have seen the selections processes go in a sense whereby people are just disqualified because somehow they don't like their name, and their name is attached to a name which politically is being censored, as well as struck off from the role as being people that can be preferred for anything in the public sector. So are we going to select on a fair basis where we give everyone a chance and an opportunity? Or it's going to be, for instance, a GNU selection preference because we are in a GNU administration? You know, because these things do happen where you see people saying, no, this one comes from the previous administration, we don't want them in this particular board. These ones were from, for instance, Mbeki's era, and we don't want them in the board. So can we have a clear selection criteria which we as a committee need to formulate and agree on those rules, to say, are we going to subject this to a proper fair public process? And the concept of the public participation, very important. When is it expected to happen? And what do we refer to as public participation? You might take it as a silly question. Some of us are new in Parliament, so when you say public participation, we're expecting something else from what we know in the past. But in public participation related to Parliament, it's a different matter. And what does it entail in terms of its public participation process? Are we subjected to go to all the provinces and call everybody in communities, in society, and saying we are conducting a public participation process, etc.? So the clarity on that is critical, because I wanted to have that legal opinion based on those really periphery issues that are more important. And then the other thing, part of it is, these boards, how are they broadly represented in respect to communities and languages? We've got, for instance, official languages in South Africa And in most cases, boards are just, sort of made up on the basis that, everybody else should be on a board, especially if they can talk good English. If they don't have the best of English, are not necessarily considered because they are not seen as people that can add value because their English is not polished and is not that good. So that's another point I wanted to raise on this matter. Our critical community participation is usually limited when it comes to those issues because we only prefer people with an accent with polished English to be in part of these committees. And then last part of it is on this 20 selection, we select and then recommend to the minister the 20. Does he do the final selection of the required number out of that 20? Or we select and say the minister should appoint this 20, etc. The clarity on that would be extremely important and highly appreciated. And then the rest, I think, within the committee, we can then just decide on our own how we are going to carry out this whole process. But I think all the 120 names, in our view, should be given an opportunity to have a say, even if it's a 2-minute presentation on a screening level, for us to satisfy that this is a living person. It's not a bogus CV. It's not an AI generated CV. It's not somebody who was just brought into the system and has already been preferred for some reason and we don't even know about the person. A level of screening before we disqualify the 120 CVs or 100 CVs would be critical in this case. I just wanted to leave it at that. I'll make further comments in needed. So.
Thank you very much, honorable members. Can we give over to the advisor to answer some of the questions?
Thank you, Chairperson. I wonder if I could try and deal with this in a more holistic fashion. So I think I want to start by saying that the Act is clear in terms of whose responsibility it is to shortlist and whose responsibility it is to appoint. The responsibility to shortlist lies with this committee. Having said that, the process of shortlisting and the manner in which this committee wishes to do so and the working arrangements is within the purview of this committee. So you can decide how you, as a committee, want to deal with the shortlisting. Having regard to the Corruption Watch case, my advice to the committee would be that I would err on the side of caution. So the Corruption Watch case says that the 14 days were insufficient. I would use that as a guide, and I would drastically increase that time frame. Of course, having regard to the committee's program. So the committee needs to decide what the committee feels is a fair and reasonable time frame within which to do the shortlisting. In terms of, and an honourable thing is correct, in the National Lottery Commission, we did the same. I advised the committee that it was the committee that needed to shortlist and the minister would do the appointing. So it's exactly the same here. In terms of the CVs and how we'd get from the 120, so in the Corruption Watch case, very importantly, they said that, so we'd have to publish the CVs. We'd have to include the public. The public would be able to see who is up, who would qualify. And then the committee would literally have to filter that down. And in terms of Poppy, and in terms of the Act, the court said specifically that, I just want to pull it up, it said that the scant information which was published was not sufficient. Publication of the candidate CVs would have provided the type of information upon which meaningful and effective public participation could be based. The publication of their CVs was therefore necessary to ensure that the right to public participation could be exercised. Section 11(1)(e) of POPIA provides that the lawful basis upon which the National Assembly could have met its public law obligation while protecting the rights to privacy which POPIA seeks to ensure. So in essence, what the Corruption Watch says is when there's a public law obligation, a public law duty, then you would need to have all this information on there, whether there are names and that sort of thing. Of course, if the committee has the capacity to remove and redact certain information, it is within the purview of the committee. The committee can decide. Obviously, if it's labor intensive, given the number of applicants, given the committee's program, then you would not do the reductions. So by and large, the committee is going to be in charge of its own process. I'm not sure whether that answers, I'm just going through the questions by and large. Yes. So that is in essence what the committee would have to do. And Chairperson, if I have missed anything, if you can please just assist me.
Okay. Honorable members, is there anything that the advisor has left it out?
Chair, there was just those questions about the missing CVs.
Right.
Oh,
Right, 100%.
Okay.
Thank you very much. So if you look at section 87C of the Act, it says that the Act provides that in addition to persons contemplated in subsections 4A, 4 and 5, the minister must from the shortlist so compiled appoint persons to the relevant positions of the board. So if there are, as I understand the Act, over and above that, those CVs would be included in order to compile the shortlist on a reading of the Act. Does that clarify your question? You answer your question?
Does that mean we have to consider those CVs?
My understanding is that you would have to consider those CVs.
Thank you.
Honorable Njabile? Honorable Fasia Njabile? Honorable Njabile, whilst Fasia is still not on.
Thank you so much, Chair. I think the issue of the stakeholders engagement process was not answered. I didn't get really the clarity on it because we're trying to understand how are we supposed to facilitate this process and in what form and format the stakeholders engagement process has to take. That clarity would be really appreciated. If there is, it doesn't have to come from the legal advice. It can come from the committee's perspective as to how you've done it previously in the past in order to engage on this matter. Or if the board was, some of the members who know how they conducted the previous board. And remember, Chair, there was a problem with the same board a couple of years ago when even the minister at the time, which was Minister Mandache, removed one of the members of this board off the board due to the fact that that person was involved in interfering with the work of the board through, I think he came from a lobby and civil society basis, where there was, and the minister felt that this person has not been adding value and contribution. So it's quite important that we understand this process so that we don't go into the same alleyways of getting people who are going to be anti-board, yet supposed to be doing the board's work, and then just stall up the board's processes. So I think we're not asking just baseless questions. We're asking things that are quite critical.
Okay, thanks
Um,
for reminding me.
yeah, so the stakeholders critical, then the process. I did suggest that we needed to do a screening of the 120 CVs. Are they real and live people? And do they fall within the criteria of being considered? And we need to consider that from a committee point of view. The issues of women, youth, people with disabilities, as well as people from previously, disempowered bases and background who are mainly never considered. Most of our boards are made of elites, people from high class societies, and people who are only preferred, and they rotate through boards throughout the country. You find one person is actually employed in more than 10 boards. So all they do, their life is just being part of a board member and never offering opportunities to other players and participants. So I wanted clarity on that question.
Okay, thank you, Honorable Fasia.
Thanks, Chair. Apologies, as you know, we're just preparing for the fiscal sitting later today. I'm not entirely answered. So what I was trying to understand, I don't think anyone's disagreeing. We agree that the CVs must be published in the interest of transparency, etc. But in order for us to meet the POPI requirement, we have to redact certain information. We can't send out people's cell phone numbers, addresses, etc., etc. Now, what I'm trying to understand is if we as the committee do not have the capacity for that, given that we are understaffed, is it within the legal framework of the Act for the department, in terms of that shortlisting of 120 that has come to us, is it okay for the department to redact the information on those CVs so that we are the ones who are publishing it? So Parliament will be saying, here's the 100 or however many we decide, whether we pre-screen or not. That's actually, okay, let me separate these things. So we will publish it as Parliament, the actual CVs. But in terms of the process of going through 120 CVs, of redacting line by line of what needs to be removed as per POPI, is it within the legal framework for the department to do that, or is that an overstep from them? A. B, I don't know about the Corruption Watch case. This is where I'm unclear. If we do a pre-screening and we whittle down that 120 to, let's say, 50, I'm just making an arbitrary number, are we still fine in terms of transparency and accountability? And I'm asking this because it would be very difficult for us to conduct 120 interviews to make some of the timelines that are necessary here and meet our requirements on this upcoming budget. So it may be necessary to do pre-screening, whereas our researcher goes through it and says, well, these people meet the requirements, these don't, whatever the case may be. Or do we just publish all 120? That's also quite important, Chair. I'll leave it at that for now because I can't ask my follow-up questions without answering and understanding this. Thank you.
Honorable Mylan.
Thank you, Chair. Chair, I just wanted to come in on what Honourable Nchabaleng said. Yes, the Minister did remove a member of the board, and that was subsequently taken to court and overruled because the Minister did not have the power to do that on the basis that the grounds that he removed that member were not valid. So we need to be careful about inserting ourselves into other processes here. We are specifically looking at an appointment process, a shortlisting process, and a process whereby we need to find suitably qualified people, suitably representative people to represent the concerns of South Africans about nuclear safety. And we need to remember that that is the mandate of the NNR. It is not to promote nuclear as a lobby or anything like that. It is to promote nuclear safety. And if we focus on that, then we will be doing our job. I just want to clarify that. Thank you, Chair.
Honorable Paulson.
Thank you very much, Chair, and I agree with the Honourable Milam that this shortlisting process, in terms of ensuring that we have suitably qualified, or that the suitably qualified requirements are met, we need to know that that these individuals with divergent views have a constituency, that they represent the communities they say they represent, whether it's the unions or whether community representation. And that can only be determined through an interview process, or else we're going to be sitting with the board and people are going to say, but I don't know this person that's supposed to be representing me. And I think the Honorable Nchabaleng mentioned it as well. It's we need to make sure that we have a diverse board where even the language issue is taken into consideration, because to a lot of people, although we all speak English, or most of us, people are more comfortable in their mother tongue in terms of who represents them, if they're representing communities. So I think an interview process is important, and it must be conducted in public. If we're going to invite public comment on the CVs, I think, and it's all around the transparency, Chairperson, we need to know that these are truly representative people, and that it's not going to be where people are once again appointed because of their proximity to people who will be making the decision. Thank you very much.
Okay, Honorable Trin.
Yeah, thank you, Chair. Chair, I think my final comment here is just going to be a very broad one. And I think I take into consideration what my colleagues have indicated about, processes and ensuring that we have, the proper demographics in place in the selection process. But I think from a very broad, just looking at a very broad stroke, I think let's be careful that we also don't get ourselves entangled unnecessarily in the process. And I would like to recommend that what we do is we look at other committees who've had to go through this process, like the one I've mentioned in DTIC, and the legal advisors confirmed that indeed she was also a part of the process. So I'm saying that let's look at how did those the committee, the secretariat, the department, how do they handle that, and then apply similar processes. And if the committee wishes to tweak it here and there, that's fine. But I think in terms of the broad strokes, let's look at what has been done, what has legally complied, and then apply that particular process. Thank you, Chair.
Okay, thank you. Thank you very much, honorable members. Can I give over to the advisor, and then others, I think, will also discuss it with the committee members, and also who have given a leeway on how to go about. And the reality of the matter, some of us are having a previous experience in terms of this. I really don't, yeah, let me give the advisor so as not to waste the time.
Thank you, Chairperson. So I want to once again just refer to the Corruption Watch case where the court held it dealt with the Chapter 9 institution and the appointment of the Gender Commission. And the court I know that Corruption Watch had asked the court for a period of 18 months, and the court had said, that was, for want of a better word, excessive. And the court was of the view that 6 months for this sort of position, was more reasonable. And that's just to give the committee an indication that the time it takes, 6 months is a long time. It may not be necessary for this appointment, but it has to be a reasonable time. It has to be enough time to give you as the committee a proper time to go through and to make make informed choices and decisions, and not it shouldn't be rushed. So it really has to be something that the committee sits and decides on. What is a reasonable time for us, given our program and given what we need to do, what we are faced with, the number of applications and so forth. And then also with the Corruption Watch, in Corruption Watch, it said Section 11 provided for the publication with consent of a data subject. Now, what you could do, just and I'm just saying what you could do. I understand from Honorable Hassan that there are capacity and staff constraints, but hypothetically speaking, you could get the consent of each applicant. So Section 11 provides for that. But Section 11 also excludes unlawfulness for the publication of personal information if it is required to fulfill a public law duty. So it really is a weighing up exercise, and you'd have to see how best you as the committee could do it. I don't think that, well, it is my view, let me say that rather, that the screening and shortlisting should be handed over to the department and then back to this is the committee's process. The committee needs to do this, and how you do it is what you decide as a committee. So, for example, if you were to sit and do a screening just in terms of CVs, and you were to whether that down to half the amount, and then if you wanted to interview, hypothetically speaking, the balance, it really is something that you as a committee needs to decide. And the legislation that I have gone through with you is a guide as to what is permitted and what is not permitted. But in terms of process, in terms of stakeholders, in terms of who you eventually appoint, in terms of language, in terms of that sort of thing, is within your purview as a committee. And as Honourable Thring said, look at what committees have done in the past, what was acceptable, if it is the first time that you as a committee is doing this. But the Act is a guide. The Corruption Watch case is a guide as to what the courts expect from us as Parliament, and that's essentially the best guidance that I could give you. Look at what we've done in the past, what passed constitutional muster, and look at what didn't pass constitutional muster. Corruption Watch, we fell short. The court said we failed in our obligation. So use that as a guide, use the Act as a guide, and essentially it is your process. Thank you, Chairperson.
Thank you very much, Advisor. And now it's the time for us to release you, and then we can also engage with members of the committee. Really, we'll also use our experience in this, but guided by the as you have said, the Act, and also whatever that is needed and everything, we have to consider it. I think the members have tried to express and ask their questions as much as they can. Thank you very much for your presence, and we have to release you. 10 o'clock has passed, and I really appreciate to have your time. Understanding that there are questions that you didn't answer, but you are saying it relies on us really to discuss that. I'm happy that the members are already setting up the criteria on how we can do this, so which is good. They are proactive on it. Thank you very much. You are excused.
Thank you, Chairperson. Chairperson, I accept that there may have been a few questions that I may have missed. And just given the time constraints, I'm more than happy to assist the committee. If the committee wants to just drop me an email or whatever the case may be, I'm more than happy to assist and to help in as much as I can. So my apologies for missing questions. But like I said, I will make myself available to assist any of the members of this committee. Thank you.
Thank you. Thank you very much, Advisor.
Thank you.
You are released. Honorable members, there was a question that was asked by one of the member in terms of when are we going to start this and what is it that we're going to do. We wanted the legal advisor to come and just brief us. Then out of that, we are going to draw up our program in terms of when are we starting and what is it that is going to happen. The only question that I didn't have is that, the answer that I didn't have is whether was this budgeted in our committee, because definitely when we invite stakeholders and all this stuff, and we definitely have to have a budget on it. So those that have experience on it, they must also assist in that. Honorable Bapti.
Thank you, Chair. Chair, I think it's got to the point where we've got to obviously apply our minds to the process going forward. And I would ask that for those who have had the experience before, that they just outline the process. I have my own understanding, but it might be not quite as accurate as it should be. My understanding is that the 120 plus the other CVs that have been received would have to be advertised after being made compliant with POPIA. We would then have to consider those together with commentary from the public and then produce a shortlist through our own internal process. But I think it would help us just to find out or to hear how the process ran previously, rather than reinventing the wheel. Let's just try and get through this in a constructive way. But I think there also is a time concern here. We need to get it done. We can't stretch this to too long a period of time. That regulator board needs to be established in the interest of safety.
Okay,
Thank you.
you. I see the hands of Honorable Paulson and Honorable Jabuleng. I think it's the legacy hand. Maybe I can also hear from them.
Chair, my apologies, it's a legacy hand.
Okay. Honorable Jabuleng?
No, Chair, I think maybe I noticed that the questions that were flighted from our side were not answered. So I thought we should actually maybe within the committee's purview create our own process that qualifies or aligns with this whole thing of making sure that we can carry out this job. One is to finalize as to how we are going to agree on carrying out this whole task. The question of stakeholders engagement, period, process, and how to do it was not answered. The diversity question, as well as the screening question, who and how we're going to screen, were not attended to, but I understand the limitations. We can't expect legal service to tell us what to do. They were just there to advise on the preambles of the, or,
What time are you going to
the law.
record, Aisha?
Yeah.
Yeah,
Who's
I'm on
it?
the platform. I don't know, maybe
Who is
let me
talking?
excuse
Paulson?
myself.
I think it's Honorable Paulson. I don't know what time is it talking about. Okay. Excuse me for that, but I think I've captured on what you were saying. Really, when I'm trying to get into this, honorable members, this is our task. But Honorable Bapti has outlined that first and foremost, we need to get the list of these 120 and publicize them. And then the second step is by that time when we do, I think we need to have a roadmap in a simplest term. We need to have a roadmap of saying this time we'll be publicizing them, this time we'll have the shortlisting, this time we'll do this. And because at the end of the day, out of the 20 that was supposed to shortlist, we'll have also to pass through the minister. So all those, we need to have a roadmap. I will ask Uli, meanwhile, Ariko is not with us, to assist us in terms of drawing a program and so sort of a roadmap in terms of going forward. In terms of the stakeholders, we can also agree upon on how do we think we can approach these stakeholders, understanding that definitely when we are shortlisting, we'll look at those things and we'll first set up the criteria as at least a person who had an information and a clue on what is it that is happening in the shortlisting and also in the whatever interviewing of these things. We understand that we will set first and foremost the criteria. What is it that we have to look at without even touching the CVs? We definitely have to have that. And the job what is it? Job or role or function that they are supposed to do has already stipulated by you instead, and it will be there in the advert. And comments from the communities and stakeholders will definitely have to be also looked at and considered. So now I really, out of these sections and rules and laws and whatever, we have managed to get them. It's cool and good now. Let's go forward and look at when are we going to get the CVs. We haven't managed. This was sent to Ariko last year, but it was towards the end of the year. So that is exactly why it has delayed. It's February now. We don't have to track this. In terms of the budget, I haven't been answered. I thought that Honorable Tring will assist us in telling us that whether the department, the budget for the portfolio committee for getting into this job, is it there or what do we do? Or Honorable Mylem, if they are in the platform.
Chair,
If-
yeah. Chair, it's one of the reasons I can't recall, I can't answer that question, Chair, but I think that's one of the reasons why I said perhaps what we need to do is speak to the other committee. I think even if we call DTIC and speak to the Secretariat, the Andre Hermans, because he was actively involved in that process as well, should be able to get some quick answers. Thank you, Chair.
Okay. Okay, thank you very much, Honorable Tring. We can even ask direct from the House Chair to check whether is this accommodated. It doesn't take a while. I can take up a phone and check up what is it that is done. I don't want us to prolong this, but there are questions that haven't been answered. Understanding that we can also answer those by ourselves as the committee, because this relies on us and we have to come up with clear criteria on how are we going to do. But we are really unable for now to go with the roadmap without having something written down, and also look and maybe check the time frames, because I was looking at the 30 days, that is a month, it's too long. we need to try and make shorter than that and make sure that we do it the way that the law is allow us to do. Anything, Honorable Bapti?
Yes, Chair, the department has been through this process several times. So it's not something that hasn't been done before. And I'm quite sure then that within the department, they understand how the process should unfold. Getting the CVs compliant, popular compliant, and advertising them, that can happen immediately. There's no reason why it shouldn't. The time that our time will be consumed, and once that public participation process has ended, and let's say it's 3 weeks long, after that 3 weeks, we then have to consider the total batch of CVs together with public comment. And that's the process that we have to involve ourselves in, and we've got to make time in our program to do that.
Okay.
We can then also decide after we've received the public commentary, whether we want to interview, and it doesn't mean we have to interview everybody. We could do our own screening and then interview those we believe are, say, the top 50, whatever the case may be. But I do believe that the department has a role to play in assisting us the administrative work of redacting where necessary, and in putting the documentation together and helping us through the process.
Okay, it's fine. Honorable Fassi?
Thanks very much, Chairperson. I agree with Honorable Bapti. I think we can hear from the department how it's been run before, and they may also be able to shed light on whether they have budget for some things like the redaction, etc., etc. But the approach that Honorable Bapti has put forward, I think, makes a lot of sense because that work can already begin, i.e., that is the publishing of those CVs so that we can get public comment. The process can start because the problem is until we get the ball rolling, nothing can move forward. So I think that would be very useful. Perhaps we can ask them to come to a meeting, or they can just clarify, maybe even in the next day or so. Perhaps we can find some virtual time for a short 1 hour virtual meeting with the department this week to just finalize this so that we can ultimately get the ball rolling. But I think Honorable Bapti's proposal is a good one. Thank you.
Okay, thank you very much, honorable members. Excuse me for that. I think now, oh, is the department present with us? Aibu.
Yes, Chair, good morning. We are here, Chair. We've been listening.
Were you present throughout, or you have just joined now?
No, we've been present throughout, Chair.
Were you invited in this meeting?
Yes, Chair, we were invited. If we were not meant to be here, my sincere apologies. But my understanding was that we were invited to be part of the proceedings.
Okay, come up with whatever input.
Chair,
I
good
thought it's the portfolio committee members only. I didn't know that even the department has joined us. But nevertheless, continue with your input, Honorable Subesh.
It's not honorable, yes. But good morning to Chair. And again, my apologies if we were not intended to be here. We did receive the invite, and it came across as we were meant to be. I did see that the CEO of the NNR is also on the platform, together with two colleagues from our legal section in the department. Chair, perhaps just to clarify three things. The first is that this is the first time we're undertaking this process. This is the only entity for which the department is responsible for, where there's an explicit requirement in the Act that requires a parliamentary process. So you'll have probably seen that in the past 4 or 5 months, we've replenished almost all of the boards. And none of those have gone through a parliamentary process because the enabling legislation for those respective areas didn't provide. So the NNR one provided a very specific requirement that it requires a parliamentary process, and hence we were deposited in the manner we had. Also, I'm saying it's the first time because this particular provision comes about as a result of an amendment to the NNR Act. And so it's the first time we're replenishing the board under the amended Act. And so that's why also for the department, it's really the first time we're proceeding to engage on this process through a parliamentary process. So unless if the colleagues, Chair, with your permission, the legal team has other experience, we've got colleagues who also served in the former DPE and have got extensive experience on how board replacements were handled. They may, Chair, with your permission, I'll call upon them to provide that guidance to the committee. That's the first thing, Chair. The second one is that, and I'm really saying this with the utmost of respect to the committee. I'm in no way attempting to interfere in any way in the work of the committee. I did just want to caution that the current board expires in and around of August of this year. So, I mean, I've heard in the legal proposition, 6 months already was raised as an extreme example. I just think that as a committee defines its process, just also to allow us the latitude to conclude all of this process in such time that we don't have an absence of a board. In other words, before the August expiry of the current board, that we would have concluded all the processes that require us lawfully to do to put in place a competent board. And we also, apart from the fact that Minister also has to apply his mind, the cabinet procedure also requires all boards to be processed via cabinet. And so we would also, once the parliamentary process is concluded, once Minister has applied his mind, would also have to take it through a cabinet process for cabinet to finally endorse. It's not an endorsement because the law is not doesn't require that, but it's a working arrangement within cabinet, and we've been asked to comply with all of that consistently as we've done with the other boards. And then the third point, Chair, was just the Honourable Milam had referred to CVs that were sent to the ADG's office. Now, again, I'll take your guidance, and I don't want to act in a manner that may find me in default of what the committee decides. We had advertised on or about, I would imagine, July, August of last year, calls for nominations for members of the public to make nominations for various boards, including the NNR board. And there was a provision how those nominations would be made, including where the CVs would be deposited to, and that process was managed entirely by the legal team within the entity oversight branch. So at no point was CVs asked or intended to be sent to the DG's office. So anything that would have come outside of the advertisement process would have not found its way into the nominations because it was outside of what the process had required. Now, I'm not aware of us having received CVs, and perhaps again, Chair, with your permission, Mr. Makubela, who's here from Legal Services, can just weigh in. But as far as I am aware, the 120 CVs that we had deposited with the committee were done so, based on what we had received through that process. No CVs were excluded. We had provided the full list of CVs as we had received them. So I'm not aware of any other CVs that had come through any other process. So I just thought, for the purpose of the committee, I needed to clarify that because it was indicated that the CVs had been sent to the HHA. Chair, on your guidance and with your permission, if you require any further elucidation, I'll ask Mr. Makubela to weigh in, Chair, with your permission. Thank you.
Okay. Honorable Prince.
Thank you so much, Chair. Chair, maybe let me bring the committee to a recollection. It was last year, I think it was during a debate of this electricity department with the minister, where I raised the question of boards. And the minister did indicate clearly that, yes, the committee has a duty in respect to one board with regards to doing the board selection as well as the criteria for board processes where we can decide, because we had raised a concern around the composition of boards and why we're having this recurring problem. And he even further said that if we wanted as the committee to amend the legislation in order to allow committee to start taking on other board processes in terms of selection and recommendation, we have the purview to do that. So I recall very clearly why even the NNR, because he did indicate in that response that the NNR is actually one only single board that falls within the electricity mandate. that we are able to carry out this process. And he has actually carried out his obligation by bringing this responsibility. In his recommendation says that the department can carry out this activity on our behalf. I am not against the department doing that, but I'm saying that as a committee, at some point we need to create some level of institutional capacity within committees to can do this function. The department, if it has already actually co-opted itself that it can assist in this process, we would highly recommend that they come on board and handhold us and enable us to work faster and quicker in order to achieve the August deadline. And that deadline, we can't achieve it a month after August. We have to achieve it even a month or several months prior to August in order for us to be ready and to show that we are really leading an effective committee. So I do recommend that the involvement of the department, the issues that was raised on the CVs, I think we should table it properly and actually get it properly debated, because it's a new issue which my apologies. Am I audible?
Yes, you are.
Yeah. I said the question of the CVs sent to the department, I wasn't aware of any CVs that were sent separately to a separate department. And on that basis, we needed to really get to understand how did that process happen. If it falls within the prerequisite requirement, we need to really be aware, because we don't want to be dragged again, the committee being taken into task for having flaunted the process. The offer to assist us by the department, which was already made on the table, should proceed in this case and assist us with regards to finalizing this process of making sure that we can do the board selection, as well as the recommendation to the minister. Thank you so much.
Thank you, Honorable Chabaleng, Honorable Fasia, so that we can give over to Mr. Makubel.
No, thank you very much, Chair. Let me also, in line with other honourable members, including Honourable Chabaleng, appreciate the assistance that the department is putting forward. I think we're most certainly going to need it, especially if we're going to meet those tight timelines and some of the challenges that are required to meet the requirements of what public participation is now requiring after the particular case of Corruption Watch versus the Speaker. I want to clarify something, and perhaps Chief Director Makwela can answer it, or Acting DG. The way I understood the August timeline, and this is the question, is that not for future vacancies? The way I understand it is the current 2 vacancies that we've got, that's community representatives or, representatives of that sector, as well as labor, are currently empty now. They're vacant now. And so we actually have to appoint as a matter of urgency, if I'm correct, or at least that's how I understand it. And then in August, we will embark upon another process to appoint whatever vacancies come up then. That's how I understood it. But if I can just be clarified, because now I'm a little bit confused on the matter. Thank you.
I think the end August is also talking about the other members, not the ones that we're looking at. This one is supposed to have been started, at least the earliest. Okay, thank you very much. Can we give over to Mr. Makubel?
Thank you, Chairperson, and good morning to the Chairperson. Good morning to the honorable members and all the esteemed colleagues online. I would like to sort of reiterate or to emphasize the response that you've given with regards to the August deadline. The August deadline is the entirety of the remainder of the board that is in place now. At this point in time, we are dealing with those 2 posts that had expired sometime last year. And I think I would also like to bring to the attention of the committee that given that the process is unfolding now and it may have some difficulties, we may have to think along the lines of trying to combine both processes, because at this point in time, we are in the process of gazetting and advertising for those positions that will be vacant in August. And I'm worried that given the time, we may not be able to meet that particular deadline. So the possibility may be that we may need to just simply combine both processes. But I think I would leave it up to the committee to decide as to which way will be the best way forward in approaching this matter. Secondly, being from the Department of Public Enterprises and having been merged to the Department of Electricity and Energy, the SOCs that fell within the purview or within the portfolio of the Department of Public Enterprises did not have legislative requirements as it is similar to this current legislative requirement that we are faced with. And then on the issues of the CVs, in terms of the legislation requires that the department, on behalf of the minister, needs to gazette and advertise. Thereafter, once the advertisement has been completed, our role it's nothing but to hand over to Parliament. So there aren't any applications or CVs that would have been sent to anyone other than the designated email address serving for that particular purpose. And that purpose of that email address will end on the deadline or on the closing date. Anything that will come thereafter will have to bounce or won't find its way into this process. So these 120 applications that have been forwarded to Parliament, these followed the process that was outlined in the advertising process. And I would also like to reiterate that as we work together as the department, we are willing, and within the legal team, we are willing to work together with the Parliamentary Legal Council to ensure that this process is run as smooth as possible, to ensure that there would be no conflict that arise out of the process. So I can reiterate and confirm that we will avail ourselves to assist in any best way possible to ensure that this process is completed in a timely manner. Thank you, Chairperson.
In terms of your advice, in terms of linking this one of August and also this one that we were dealing with, is the advert that you sent out clearly stipulating all what you are saying? Is it not a flaw to combine the one of August, that is the rest of other members, and then with these two? Is it not going to be a flaw somewhere?
No, Chairperson, I do not foresee it having any flaws whatsoever. In any given case, these are vacant, and if we were to wait for the new advertisement, because both processes would have been would have gone through the normal legislative process. So when we advertise for the ones that are coming up in August, they will stipulate that these are the position. Remember, these ones that we are now dealing with, it's nothing else but community and labor. And it specified that it would be that. So the ones that would be coming up in August, they will also specify that these are pertaining to these particular positions. So there is an outline of which skill sets to look for. So there wouldn't be any flaw in terms of responding to your question, Chairperson. Thank you.
Okay. Honorable Maila, I still have
Sorry,
another
I just need to
follow-up.
understand this. I just need to understand this quite clearly. Mr. Makubela, are you saying that these ones that we are looking at now, their appointment will only run until August, and then when the entire board is replaced, they will be replaced again? Or are you saying that theirs will run past that August deadline and the other positions will be the ones that will be filled? I just need clarity on that, please.
Yeah, thank you very much for that follow-up, Honorable Milam, because that's what I'm going to ask, whether the two that were going to do it right now, will they be able to be accommodated for the August? Because it is now, from now, that is March, let's say March, April, and then August, there will be also another team that needs to be filled up. Okay, sure. Over
All
to
right.
you,
If
Mr. Makbel.
Thank you, Chairperson. Nothing in the legislation precludes us, or at least precludes the minister, because this is minister's discretion, that the appointment is 3 to 5 years. So the minister will decide. In fact, it is a normal board appointment practice to have the board expiring in different times, because then it ensures continuity, historical legacy, knowledge retained, and all those sort of things that sort of keeps the board functioning in a normal manner. The reason why I suggested, if this, let's take, for example, if we were to proceed in separate processes, then these two that we'll be appointing now, the minister will exercise his discretion, within his purview, whether he gives them a 3 to 5 years. We are not filling these positions to the end of the term in August. They will start their own new, fresh term, which the minister will decide as to whether it's 3 years or 5 years. And then the reason why I was giving this suggestion is I'm worried about time and the processes that it will take. And it would seem to be a prudent thing to combine them, but also it's up to the committee to decide whether they want to run two separate processes. Thank you.
Okay. Honorable Njobelen.
Thanks a lot, Chair. No. I think this thing just threw a spanner in the works here. Quickly, maybe we just want to get a bit detailed. So this process, Mr. Makubela, you're referring to is we are not going to open up a new application for all the board members of NNR coming in August. You're saying that we can take the existing application and fill in the new board members process. I just wanted clarity on that, because, and the question of continuity, etc. I think we have to have a separate, almost debate on that, because we need to refresh this board, and we need to give it a life that the committee can hold it accountable as a result. So if that application, as you're saying, has not, the gazetting as well as the opening up of applications has not yet ensued, maybe we need to define this in two steps. One is to filling the existing vacancy of the two applications with this 120 CVs. Then secondary to it is, as soon as you gazette and open up the applications, we then dovetail the process to include, after the closing date of the applications for the responses to the new board, then we include that process and we do a continuity of it in respect to finalizing the appointment of the new board. Yes, the interim, it can be made as an exception to say we should include the two candidates into the new existing board, or retain. That should be a committee decision, because it's in the committee purview. So I just wanted that clarity. We have two processes. One is the main one, which is the two vacancies until August, and then the one is the starting of August till the next 5-year period, that to be filled. And we should be now preparing ourselves for that. That's why I said we really require the department's assistance on this process so that we can work it faster. Chair, the other thing is, this kind of activities, we don't have to wait for a week or a month to schedule it on our calendar. We can schedule it after, for instance, when we've done plenary work, and we schedule it as an item line on our meetings to include for engagement on a special purposes. The only thing that's going to be precariously difficult is to undertake the public participation process. And in this case, as we said, we require the assistance on this basis.
Okay, Mr.
Thank you.
Makubel.
Yes, thank you, Chairperson. Thank you for your question, Honorable Nchabeling. Just to be direct, no, we can't consider the current applications for the board members' term that is expiring in August, for the simple reason that you'll recall earlier, I stated that, in fact, the legislation itself does state there are different categories of board membership. Amongst them, and in fact, the ones that we are considering now, if I can remind the committee, it's labor and community representative. So when we advertise them specifically with that constraint or that limitation that this is with regards to labor and community. The ones that will be expiring in August will be for different categories. These are for the simple term called independent executive directors. So in terms of their skill sets there, we would be looking at such skill sets as law/legal, commercial background, nuclear knowledge, all other scientific, environmental knowledge. So just to be direct, and to illustrate that these applications can be differentiated, we can't use the current application. We were already in the process of gazetting for the August, and in any given case, as I've already stated, is up to the portfolio committee to decide whether they'll merge. The process can proceed as far as the current applications are concerned in respect of the labor and community representative. However, pretty soon, sometime around August, sometime around March, we will be sending a batch of those applicants as it relates to those independent executive directors positions that will be expiring in August. I was just merely advising in the interest of time to ensure that both processes are concluded by August so that when the current board's term expires, the committee would have done its duty of advising the minister, and the minister will also have time to be able to consider those board appointments for August. So I hope I've provided clarity, Honorable Nchabeling. Thank you, Chairperson.
Yeah, thank you. You have also assisted me in my question because that's what I was asking. Uguti, if we are using these, the ones that are now advertised or published, is it not going to be a flaw to use those for August? So we have answered us. Thanks, excuse me, Honorable Bapti.
Yeah, and then in light of what we've heard, I'm happy to propose that we proceed with the one process. Let's get this on the road. Interests of time and having a complete board from August onwards. Did you hear me, Chair?
Honorable Fasia, thanks. Yeah, because I understand that there will be also a time for us to go and campaign for the local government elections. So definitely there is something, but we will see along the line. Let's just not cross the river whilst we haven't managed to arrive. Honorable Fasi.
Thanks very much, Chairperson. I had the same question as you, but it's been answered by the Chief Director. I'm therefore also agreeing with the proposal that we continue this process for the two vacancies, for the community rep and the labor representative, as of course their terms are on a different timeline to the August arrangement. And then of course, once August comes or whatever, we can then start that process as well. But it would be important to have an established board by the end of the year, A, but B, by starting with this process, at least two of those board members will have had some overlap between the two different boards. And I think that is very important for stability of the structure and the entity. And I think it also assists us in learning how the process works. So I think we've got our work cut out for us, but we can continue with these 2 vacancies. And then as the time arises and other gazetted vacancies are advertised, we can start that process as it comes. But I think let's continue because there's a lot of work to be done. And very importantly, we are also learning how it all works. So I think it's important that we continue. Thank you.
Okay. Okay, thank you very much, honorable members. Now I think we have managed to ask all what we wanted to ask. And I don't think we can further discuss this one unless there is one member that's hand is up, and I don't see any other hand now. You know what I think we
Yeah, I
have
think
to
my hand
do.
is up.
Is it not the Lagos one?
No.
Okay.
Chair, what is the way forward? Because I seem to be confused. We had a presentation from legal and we got the inputs. And from a committee standpoint of view, we're supposed to take a way forward. And after the clarification that there is 2 concurrent processes that are running, one is still to start, and then the other one is the existing, which means actually the brief we got could have been maybe insufficient in understanding the steps. I agree with Honorable Fasia when she states that we are currently learning. And as I said, I would really appreciate if the department could educate us along this process so that we can actually enable the committee to have this internal skills for this type of processes. But we still have no clarity as to where are we going, what are we doing.
Thank
And
you very
maybe,
much.
yeah, please can you
Yeah.
assist us?
Thank you very much. Remember, even before the chief director came in, I said we have to have the roadmap in terms of saying what is it that's going to happen from when and how long are we going on, the time frames on that, and what is it that we're going to do. That's exactly what I said. So from now, what is supposed to happen is this thing of publicized, this 120. That's the start, which I think the department is willing to assist us and tell us on where and how to go about. But as the committee, we'll also have to use our discretion according to the debates and deliberations from honorable members, the inputs. But the first and foremost, we definitely have to start there, and we have to have the sort of a program. That's what I called roadmap in terms of what is it, and it will be sent to you so that we can know on how and where are we now. That's my way forward, and that's how I see it. Otherwise, there is no other thing except to do and implement it, to make it a point that at least we will do the second phase on another time, and we will see along the line what is it and where are we going to get stuck, and then we'll ask the department to get in. But they mustn't interfere with the programs and the processes of this. Thank you very much, honorable members. I think so far so good. What needs to happen now is the work and the implementation. Lee, in terms of whilst Ariko is not with us, is also going to be of assistance, and also the legal advisors that are with us are also going to. We will definitely send maybe, I don't want to put by saying at least today it's Wednesday, Thursday, Friday, you might as well get the program of what is it that is going to happen, when and when.
Chair, the
time
stakeholders
frames.
question. I think we're avoiding a critical issue here. What is the resolution on the stakeholders process? Nobody has explained to us what needs to be done in respect to the stakeholders engagement. What are we talking about? What does it entail? How, when, what, where? Please, can we be clarified on that?
Can I be assisted by other honorable members that have managed to hear? Because the first step, Honorable Nchabeleng, is this one of publicized and wait for the comments and all the stuff. And then I said the roadmap is going to have dates on what is it. What do you suggest in terms of this? Because definitely you have an idea or something that is in your mind that you think it needs to happen. You can come up with.
No, the department does have knowledge with regards to what is the nature of the stakeholders program and what does it take in a form and how long is it running? Is it a day? Does it take a month? Does it take months, etc.? So we wanted the clarity on that. And I asked it earlier with the legal advisor, there was no answer. I said it that the committee has done this rodeo before, and there are members that might have an experience. There was no answer. Now I'm asking to the department, and there is no answer. Thank
Okay.
you.
Honorable Fasia, I can answer even myself about that one because it can't be a day, definitely. We definitely have to give space. Honorable Fasi, over to you.
Thanks very much, Chair. Just a few points. I think we must, of course, in fact, we have to be guided by the actual act, the NNR Act, which deals with like who qualifies, who must be consulted, etc., etc. But I agree it is within the ecosystem with these various stakeholders. But maybe just to clarify, we're not passing a piece of legislation here. So we don't need to go from province to province, very specific community to very specific community, and hold public meetings in a community hall. That's not what is required of us from the way I understand it. It's to basically ask the stakeholders in the ecosystem, what do they think? And because we're dealing with the nuclear ecosystem, it's one in which we can be a little bit more innovative. We can even have virtual hearings, or hearings is not the right word, but we can have virtual consultations, etc., because you're not dealing with an industry that doesn't necessarily have access to these things. You know, there may be particular think tanks and ideas and processes that can be put forward. So I thought it's just important to clarify that it's not going into province to province, region to region, because there's no time for that, A, but B, that's not what the Act requires of us. The Act gives us the space to consult stakeholders in the industry, but also to not necessarily be hamstrung entirely for it. I think where it becomes sticky is once we publish the CVs, we must give at least 30 days for actual public comment and allow that public comment to be fully transparent and open, etc., etc. So I think that's a lot of where we must focus our concerns and our attentions on. And I think even before this, the processing of gazetting and advertising would have been sent to these various stakeholders, but perhaps the department can clarify that to make sure that we're not missing out on a very important sector that is there. Thanks, Chair. That's my understanding.
Mr. Makobela, can you get in?
Thank you, Chairperson. I think the Honorable Fasia has succinctly captured the process with regards to the stakeholders and in terms of what needs to happen. Honorable Nchabeleng, you will recall that these matters now, they now reside within the parliamentary processes or the portfolio process. We will certainly ensure that working together with the parliamentary legal advisor, that the stakeholder process is undertaken in line with the processes that are to be expected as outlined and confirmed within the court cases that are outlined in the legal opinion. So as far as the advertising of the gazetting and advertising, it doesn't state that we needed to send it to any other organization. However, we took an extra step to send it to NEDLEC, to send it to NEDLEC, because NEDLEC is the arm, or rather the organ of state that is in contact or constant contact with the relevant communities and labor representatives. So that's the step that we took in terms of an extra step of advertising to further stakeholders. Thank you, Honorable Chair.
Thank you, Mr. Makubela. Honorable Nchabelenga, are you answered?
Yeah, I'm not answered. I think we are now even in a worse situation. But anyway, I think you've given us the idea. Let's go out and then come back with alternative processes that needs to be done. And then we need to sit as a committee to then decide the composition of this process and the undertaking of this particular activity. So far, everybody is just reaching and they have no clue what needs to be done. So we get the point. We're not saying people should have the solution. None of the people have the experience. So we have to create a baseline for where we are going to start and get to where. Fazia was not in the process of parliament when NNR, for instance, board was composition. So yeah, and the department seems to be new and learning in the process. So we agree, we accept, we understand. And we're saying that now let's take it upon ourselves as a committee to quickly come up with a framework plan and then now refine it with legal. Even legal didn't have an insight on this process. So we understand the limitations. We're not going to belabor the point, but we're saying now as a committee, let's do a framework as quick as possible. Then we will put in inputs. We will contribute ourselves in order to ensure that that framework aligns with the law and the requirement for the specific brief and job that needs to be done. But it will give a lot of experience to the committee. Thank you so much, Chair.
Okay, thank you, Thank you very much, honorable members. Much as I was not part and parcel of this shortlisting and all the stuff, but the background and the experience give us a little bit of a knowledge. The only thing that we have to match is the policies and also the laws and all the stuff. At least we do know on how these things are supposed to happen. So we are right by saying that as the committee, we can come up with things that we think they are supposed to have happened. And also the department is advising us and also assisting us. And the legal advisors are there 24/7 to assist us in this thing. They might not have the answers, you are right, but we do have answers, even ourselves as committee members. So I thank you, all of you that has managed to do the input on this. Let's put our minds and heads together and be able to come up with the process that at least won't be challenged in any of the courts and mustn't have flaws, and we do it the correct thing that is supposed to happen. Let's adjourn the meeting because the last other thing, there is a executive secretary that I wanted us to see, which you should also know her. And also she will be the one who will also assist me in everything. And whilst Ariko is not here, she is working hand in glove with other officials like Abo Lee and also Abo Vuyo, knowing that they are trying to stretch their arms to wherever to assist that. Mr. Ariko, usa extension ye leave of a week. Can you, Ntswaki, Malipi,
Mapila, yes, Chair.
Mapila? Okay. Can you open up your video so that the departments and also the member there she is, introduce your name and your surname correctly?
Good morning, honorable members and colleagues. Again, my name is Ntswaki Mapila, and I am happy to be a part of the committee and to working with everyone here. Thank you.
Thank you.
I'll also put my contact details on the chat for everyone.
Okay, thank you very much. We'll also include her in the group chat so that whenever I've got something that is in a hurry or in a rush or urgently, she is able to also know whom should she contact. Thank you very much. You are welcome once more. And I know that these are your brothers and sisters, your fathers and cousins. You must just treat them like that. But respect is critical to them, and they will also respect you. Thanks ever so much. The meeting is adjourned.
Thank you, Chair. Bye,
Thank you,
colleagues.
thank you, thank you. We'll keep in touch.
Recording stopped.